We are monitoring developments in the nation's capital, where the Federal High Court has adjourned the trial of leader of the indigenous people of Biafra, Nnamdi Kanu, to 6th, 7th, and 8th of May for continuation of hearing. At today's hearing, an officer of the DSS who arrested Nnamdi Kanu in 2015 told the court that when Mr. Kanu was arrested, no instrument of violence was found on him. Mr. AAA, the federal government's first witness under cross-examination, admitted that when Mr. Kanu was interviewed in 2015, his lawyer was absent. Mr. AAA agreed that those items now tendered as exhibits before the court are no longer of value. At the last hearing on Tuesday, the court granted the request for the witnesses to testify behind screen due to security reasons. Our senior reporter, Celestina Area, joins me on the news for more updates. Celestina, what more can you tell us about hearing in the case involving leader of the indigenous people of Biafra, Nnamdi Kanu?
Oh, well, about today, so far so good. The trial is going on very smoothly, and considering the evidences given by the first prosecution witness today, so far nothing incriminating has been found against the indigenous, the leader of IPOB, which is Nnamdi Kanu. So we don't know what is to come as the proceedings continues, and we don't know for sure how many witnesses the federal government is going to call. This is just the first witness, and he was cross-examined today by counsel to Nnamdi Kanu, Kanu Agabi, and wherein he made some findings that the way Nnamdi Kanu was interviewed without his lawyer present, that most of the items that were seized or collected from him in 2015 have no value anymore because it's over 10 years. But Justice James Omotosho told Kanu Agabi, which is counsel to Nnamdi Kanu, to come by way of application before the court seeking the release of some of those items, wristwatches, gold chains and necklaces, and see if Mr. Kanu can peradventure sell them and get something out of it. But so far so good, they have no importance. So it will not be of any good for either the prosecution or the defendant for those items to still remain in the custody of the court, because now they are exhibits. So the court adjourned to 6th, 7th, and 8th for continuation of trial. So the conclusion of the cross-examination of the first witness to be done, and the second prosecution witness to be called.
All right. You mentioned a while ago that it's unclear how many witnesses the prosecution would be calling. But does it appear that the others might also enjoy this liberty to testify behind screens?
Yes, definitely, because this is the position